Shall we start? Welcome everyone to the panel discussion titled Investor-State Disputes, International Finance and the Economic Crisis. We have an excellent, distinguished panel today. I'm going to start with a couple of technical issues. I shared the CLE information in the chat box. We are going to have a Q&A following the panel discussion. Please, if you want to ask any questions, share your questions in the panel, in the chat panel, and then we can address that following the discussion. And please keep your mics muted. So today we are going to focus on a very interesting interdisciplinary topic of investor-state disputes, international finance, and the economic crisis, a truly current topic. And we have three panel members. I'm going to introduce them briefly. We have De Luca of Counsel at the law firm Macchi di Cellere Gangemi in Milan. Apologies for my horrible pronunciation of the
Don't worry.
Thank you. She holds a GD and a PhD from the University of Milan, Italy, and she's a very accomplished practitioner with over 15-year experience, and she has a long list of publications, including a book chapter of a recent book titled The Legal Implications of Global Financial Crisis, which is a book of this year, and she's also a member of the exit panel of conciliators and delegated by Italy to the UNCITRAL Working Group 3 on investor-state dispute settlement reform. We also have Professor Michael Waibel of the University of Vienna, Austria, and he published many articles and books on international economic law, sovereign debt, and international dispute settlement. He has a decade-long teaching experience, including with the University of Cambridge. He served as a visiting professor at Harvard Law School, studied at the universities of Vienna, also the Paris Second Panelists and Harvard Law School, and as well as economics at the London School of Economics. He worked with the ECB, with the World Bank, the IMF, and he's one of the editors of the book, The Legal Implications of Global Financial Crisis. We also have Mr. David Attanasio, an associate at Dechert LLP in Washington, D.C., the United States. He has a JD from Harvard, a PhD from the University of California in Los Angeles. He's a published author of many articles on international dispute settlement. He serves regularly as an adjunct professor at Georgetown Law and at the University of Virginia Law School. And with Arif Ali, he co-authored the book International Investment Protection for Global Banking and Finance, which is forthcoming with Wolters Kluwer. And my name is Virág Blazsek. I'm going to moderate the panel discussion. I am an attorney at the United Nations Joint Staff Pension Fund's Office of Investment Management in New York. I hold a JD from Eötvös Loránd University in Budapest, Hungary, an LLM from the George Washington University in Washington, D.C., and a PhD from Central European University. Before my doctoral studies, I practiced law for about a decade in the financial sector, and my book was just published by Routledge with a focus on banking bailout law. So we are going to tackle a couple of broader questions. The first question, regarding the first question, I would invite Professor Waibel to start answering the question, and then the other two panel members. So my question is, what are the main types of international disputes arising out of economic and financial crisis in terms of legal basis, sector, and subject matter? So it's a very broad topic. More specifically, does investment-state arbitration have a useful role to play in resolving the controversies related to states' crisis management measures? And also, have you observed any changes or tendencies over the past couple of decades in this respect? And is it possible at all to draw a line between legitimate emergency actions and the abuse of state authority?
Okay, thank you so much, Virág, for sharing, and Virág and David for organizing this panel. I'm delighted to be here with Anna, whom I've known for a very long time, and to discuss some of these issues with you today. Yes, so I think just to respond to these questions briefly, it's fair to say that we have seen some evolution. It's of course well known that Argentina's financial crisis at the beginning of the 2000s triggered the first major wave of arbitrations directly concerning a financial crisis. Now, most of these arbitrations were not, I'd say, about the financial crises as such, but the knock-on effects of Argentina's decision to abrogate its currency peg to the US dollar. So that meant that we have diverse sectors represented in these more than 40 arbitrations against Argentina, of which the most prominent sector was the energy sector. I think if we then look at the global financial crisis starting in 2008, we have the kinds of disputes that are closely linked to that crisis tend to be more narrowly focused on the financial sector, related both to measures by host states that affect individual financial institutions, such as whether or not to grant emergency liquidity assistance, measures that affect depositors because of a bail-in of depositors, shareholders, and creditors of financial institutions. As a very general trend, comparing these two financial crises, I think there's a trend that tribunals have accorded somewhat greater leeway to host states in enacting these measures that may or may not have something to do with the more widespread nature of the 2007-2008 global financial crisis, compared to Argentina's crisis in 2001-2002 that really only affected a major country in Latin America. Now, maybe just as a starting, as an initial observation on the other questions, Virág, that you asked. So I think in terms of the question, does investor-state arbitration have a useful role to play in resolving the controversies? I think yes, absolutely. Investor-state arbitration, almost by definition, has a role to play in resolving the controversies or disputes themselves. One would hope that investor-state arbitration can help with that. I mean, it may not always successfully manage to actually resolve these disputes, but I think in general, we can probably say that investor-state arbitration can play a role. But just to play devil's advocate for a moment, I think perhaps the question that, at least from the perspective of host states, is rather whether investor-state arbitration helps with crisis resolution in the long term. So whether it plays a role, a useful role, for the state in regaining its economic footing when it is affected by a deep economic and financial crisis. And so if one looks at that broader frame, disputes with foreign investors are only a relatively small element in that larger picture. And I think here, what I would consider an important distinction between measures that are general, measures adopted by a host state that are general and affect a wide range of investors, domestic and foreign, to respond to financial crisis. These are, as a general proposition, different from measures that affect individual investors, or at least a small group of investors, based on some identifiable characteristic. So I'll leave it there for now. Thanks so much.
Anna, what are your thoughts on this broad question?
Yeah, first of all, thank you to you for chairing this panel, to David for having invited me, and to Michael for having decided to participate together with me in the discussion. Very briefly, a footnote on your first question, which has already been answered by Michael. I think that certainly I mean, it is true that the Argentina's crisis, or better to better say, that the measures enacted by Argentina to respond to its economic crisis gave rise to the first wave of cases related to connected to an economic crisis of huge dimension. But as said by Michael, the Argentina's cases were not related to, did not concern the banking and financial system, as he said. So I would say that to respond to your question, the main types of international disputes arising out of economic and financial crisis, I would say that certainly the bank measures, bank rescue measures, together with the Greek sovereign debt restructuring enacted to respond to the latest global financial crisis, have given rise to highly politically sensitive disputes. And these disputes are, just to mention a few cases, for instance, Marfin Investment Group versus Cyprus, Adamakopoulos versus Cyprus, and Cyprus Popular Bank versus Hellenic Republic. As said by Michael, these measures were highly, I mean, measures of this type, and this was highly predictable, have and had from the outset the potential to impact a lot of a broad, I would say, an ex ante indefinable pool of stakeholders, shareholders, bondholders, last but not least depositors. And they are, generally speaking, of course, protected investors, especially under bilateral investment treaties of European origin, especially those of all generation. Let's say, as said, I think that in terms of legal claims, legal basis, sorry, certainly if I look at the investment case law, including the recent cases I mentioned before, I think that I believe that the most invoked investment standards, at least the one which are more promising from the perspective of climate investors, are the provision on expropriation, but especially indirect expropriation, the fair and equitable treatment standard, and then non-discrimination, the non-discrimination provisions. But I would say also as additional point that all these disputes, in my opinion, the one especially related to the financial, affecting the financial and the banking systems, present some specific features as compared to other investment cases, in the sense that contrary to what occurs in a typical case, in a typical investment case, in these proceedings, it is, I would say, by no means certain whether the claimants actually suffer any losses at all. All the measures were enacted to save banks already technically insolvent, if not completely already failed. This is, I would say, a preliminary issue which tribunals cannot ignore. And the question is, the preliminary issue is whether the investment of a claimant investor in an affected bank had any value at all, regardless of the rescue measures, which in turn this raise other issues related to causation, in the sense that once again, admitting that investors are able to establish some economic harm is not clear whether the losses suffer are the result of a state conduct or of the bank exposure to distressed segments of the financial market, sovereign debts, or in the alternative, the result of the conduct of the claimant itself, or some other external factors. And this is maybe, I mean, these are features specific of these all these disputes on the banking and I mean, in respect of measures affecting the banking and financial system.
Very interesting thoughts, being aware also of the time frame, and we have a couple of other questions following this round. I would invite David to share your thoughts, and my understanding is that according to Anna's opinion, it's rather difficult to draw the line between legitimate emergency actions and the abuse of state authority. Michael also mentioned the bail-in, so I would invite you to share your thoughts in particular regarding those issues. And also the broader topic.
Okay. Well, thank you, Virág. And also thank you to my fellow panelists. It's a pleasure to be able to speak alongside both of you. Just to start, I want to emphasize that banking and financial disputes have been one of the most important, have been a very significant area for investor-state dispute settlement and in investment law more generally. So figures from UNCTAD on publicly known investor-state disputes say that there have been 99 disputes in the banking and finance sector, and this is out of about 1,000 total known public disputes. So almost 10% of all investor-state disputes have been in this area. By comparison, the mining sector, which is typically considered one of the main sectors for investor-state dispute settlement, has only had actually a total of 95 publicly known disputes, so actually fewer. Now that's excluding hydrocarbons, but still, I think this sector is more important in investor-state dispute settlement than it may appear at first. And the damages that that are awarded in these cases can often be extremely significant, or and including damages that are obtained through settlement. So just to give a couple examples of the the size of these disputes and some of the outcomes. The Abaclat case concerning a bond default by Argentina during the economic and financial crisis of 2000 to 2002 ended up settling for about $1.35 billion, according to public reports. The Luca dispute over over measures that the Czech Republic took in response to a localized banking crisis ended up settling for approximately $280 million. So these are actually very sizable disputes that are implicated in this sector. And as my panel, one of the most prominent areas for generating these kinds of disputes has been financial crises. Not all financial crises, as my fellow panelists noted, most of the disputes arising out of the Argentine financial crisis were not specifically in the banking and finance sector, but certainly financial crises have tended to generate the largest segment of those investor-state disputes in the sector. Okay, so investor-state dispute settlement has had a lot of cases in this sector, but has investor-state dispute settlement been important for banking and finance? And I think we can consider this from a number of different angles, from the angle of technical capacity, from legal tractability, and available alternatives. My fellow panelists focused a bit on the legal tractability and maybe the difficulty of distinguishing between legitimate and illegitimate state measures. But I think it's also important to just note that for many financial sector disputes arising out of economic and financial crises, there isn't really that major alternative fora in which you can resolve these disputes. So at the international level, banking and finance is a relatively highly regulated sector, at least through soft measures of regulation. So that, especially following the 2007-2008 financial crisis, a whole host of loosely related institutions have gained importance, including the G20 as a discussion forum, the Financial Stability Board, different fora for banking, securities, and insurance. And all of these are encouraging state regulation of these sectors in various forms, setting standards and encouraging regulators to network and set common sorts of approaches to these issues. And these, of course, have the laudable purpose of preventing a recurrence of the 2007 to 2008 financial crisis. I think it's incredibly important that we don't go, that we avoid repetition of such events in the future. But I think there's a complement that that investment protection can play at the international level, which is whereas these other international mechanisms are primarily focused on restraining actors in the international financial sector and regulating them or encouraging the regulation of them, the investor-state dispute settlement can play the role of trying to control excesses of state power when they do occur. Now, of course, the idea here is not to preclude all state measures in the banking and finance sector. We do need effective regulation in this sector, and that's important. But really, with the exception of bond disputes, investor-state dispute settlement is the only game in town outside of the domestic courts of a particular host state for an investment to actually obtain relief. Now, I had some additional comments on legal tractability, but I believe I may have hit the limit of my time, so I will pass the floor back to
Thank you.
Virág.
Excellent, very substantial information. In the third round of questions, we are going to get back to some of these broader topics. In the next group of questions, I would like to bring to the table a little bit the European dimension. In particular, Michael, first, could you please share your thoughts on the presence and the future of the intra-EU and extra-EU banking and financial investment arbitrations after the ACMA judgment, especially in the context of sovereign indebtedness? And you already mentioned the bail-in, so I'm sure that we will learn a lot from you in this respect.
Thanks, but I don't need to always go first. I'm also happy to let others speak first if that works better.
Anna, if you would like to start addressing these issues.
Yes, just a footnote, maybe in respect to the questions you raised before. I do think also, I share the opinion expressed by David. I think that, I mean, state measures affecting the financial sector, the banking sector should not be shelved from the scrutiny of international tribunals. It is clear that that said, that the resolution of individual disputes on the sector have broader implications. So, you know, I think that if I look at the case law as developed, particularly the last wave of cases, I think that the macro economic consideration, I would say the context in which all these disputes have arose matter before a tribunal. And I think that in the great majority of the cases, these considerations are going to favor respondent states. So this, as turning back to your question, the ACMEA impact on the presence and future intra-EU and extra-EU banking and financial investment arbitration. I think honestly that after ACMEA, after the termination treaty, investment arbitration is not going to play any role at all as far as concern intra-European disputes. And it is difficult to see any future for investment arbitration, considering the ACMEA decision and the termination agreement. I think that on the contrary, investment arbitration will play a role, will continue to play a role in an extra European context, albeit this role, if I look at the CETA or the new generation of agreements, even coming from non-European parties, I can see a general trend in the sense that the use by investors of investment arbitration is restricted by provisions, by specific provisions included in the treaty. So I would say there will be a role for investment arbitration in as far as concern measures affecting the banking and financial system. I would say that the same is true for sovereign debt. but the disputes, the international disputes on these sectors, I mean, the availability of international adjudication, I would say, because if I look at the CETA, I cannot speak about arbitration, but still is open, it will be open to investors, but not as under old generation treaties.
Michael, what are your thoughts on this topic before David weighs in regarding the American aspects, or how it looks like from this side of the Atlantic?
Yeah, no, thanks so much. So I agree with everything that Anna has said. I think the distinction between intra and extra EU bits is crucial. I also don't see much, if any, role for investor-state arbitration after the termination treaty and bilateral terminations of treaties, since not every EU member state has signed the termination treaty. Austria and Sweden, for example, have committed to bilaterally terminating their bilateral intra-EU investment treaties. We have infringement proceedings that the EU Commission has brought against Finland and notably against the UK. We have a member state like Ireland that doesn't have any BITs in force, but I agree that there doesn't appear to be much of a future for investor-state arbitration under bilateral investment treaties. Now, the termination agreement doesn't apply to claims and proceedings under the Energy Charter Treaty, and that's an important exception to the extent that now it's not altogether easy, I think, to envisage banking and financial sector claims under the Energy Charter Treaty, but so investor-state arbitration as a whole probably does have some limited future, but I think with this, if we look at the specific sector that we are concerned with, I don't think there is much of a future, despite some unresolved legal issues. The relationship between Article 54B and 70 of the Vienna Convention on the Law of Treaties, that's discussed in the context of the termination treaty. And I mean, I think even if there were if investors succeeded in obtaining awards, it would be very difficult, if not impossible, to enforce these awards, certainly in EU member states. And then if one sought to enforce an award against some EU member state outside the European Union, well, you run into the typical problem that you would have to find sufficient assets that are not protected by sovereign immunity. So I'm afraid I don't think that the future, insofar as investor-state arbitration relating to the finance sector, is bright in the European Union.
Thank you, David. Well, what are your thoughts on this not so bright future? Well,
I agree on a technical level with my co-panelists, but I do wonder whether we might not see that there will not be technically intra-EU investment disputes, but I wonder whether going forward we're not likely to see some major financial institutions or not major financial institutions in the European Union actually restructuring their holdings in some cases through non-EU jurisdictions. Just for non-specialists, it's been quite, investment tribunals have generally been pretty tolerant of companies or enterprises organizing their holdings through third-party states in order to create jurisdiction. Now, whether this is a good or bad practice is an entirely different debate, but in a lot of cases, this practice has succeeded in investment arbitrations. And depending on, of course, depending on the specific language of the treaties and the specific context, but you may see financial institutions reincorporating through other jurisdictions, say Switzerland, which has quite a few investment treaties. And then in the case where there is actually a dispute that arises, they would be able to bring claims through that third state entity. So we may still see some investment disputes going forward, although certainly it'll be less in the intra-EU context.
Do you have any further thoughts on this topic in the mirror of what we've heard from Michael and David?
Yes, I agree with David that maybe there might be a role for investment arbitration started by, as far as I could understand your point, started by formally for non-European investors actually controlled by European nationals. But this I would say, this is a phenomenon that I would say is not exceptional. I would say we have seen, for instance, a few cases under the Energy Charter Treaty started by Swiss investors controlled by European nationals. And we have seen also cases, I can remember at least a case in which the investors was submitting claims both under the Energy Charter Treaty and a bilateral investment treaty between Switzerland and a member state of the European Union. Yes, this is a phenomenon still possible because all generation bilateral investment treaty and also the Energy Charter Treaty, which is not a bilateral treaty but a multilateral treaty, generally include broad definition of protected investors. And so, but the new generation treaties are going to include a lot of clauses, including denial of benefit clauses, more restricted definition of cover investors, so that will, I would say, make very difficult for investors to, let's say, to incorporate in a third country, for investors national of the host country to incorporate in a third country in order to gain protection under a certain treaty. So, you know, so it is true, but I would say that in any case, these cases are going to be not intra-European Union cases, but extra-European Union cases. So reciprocity works, you know. Also, the other third country will have the same problem, you know. So.
Very good, excellent. So far we have 2 or 3 questions. So I invite the attendees to submit further questions in the Q&A or the chat box. And let's tackle a third round of questions as we have limited time. and we have already learned so much from your valuable insights. So do investor-state tribunals have actually the technical capacity to provide oversight regarding in terms of domestic and internationally as well? Maybe David, you could start elaborating on this question, if you will.
Yes. So the tribunals that resolve investor-state disputes are not typically composed of experts in international finance or international financial policy. However, at this point, there have been an extensive number of these cases, and so some of the major arbitrators are gaining experience in the sector. But I think more broadly than that, this is not a unique issue from a technical perspective to the finance and banking sector. International investment arbitration regularly resolves all sorts of technical issues that are very specific and not necessarily in the prior knowledge of the arbitrators in all sorts of different economic sectors. So details of how mining works, details of how construction works. And so I think international arbitrators are accustomed to having to, well, both learn quickly about some very sometimes arcane technical details of a field, and also are used to relying on experts presented by both claimants and respondents in these arbitrations who inform the tribunal as to what the nature of the issues are, what the controversies are, and how they should properly be resolved in the context of that particular case. So, I mean, certainly banking and finance is a technical, even particularly challenging area, but I don't think it's uniquely challenging and technical. And as I was noting before, at least for some of the disputes in this sector, there's not really much of an alternative forum.
Michael, what are your views on this issue, and have you noticed any tendencies, major tendencies in the past 1 or 2 decades in this respect?
Thanks. I mean, so I agree that with David that in many ways disputes concerning the financial sector don't differ qualitatively from other types of disputes. That is, that the arbitrators don't necessarily have and don't necessarily need the technical capability. They can, of course, have recourse to experts, and they routinely do. But I do think that there is something that is quite unique about at least some of these disputes. That is, I mean, we've seen this play out in some of the Argentinian cases. Both sides hire experts, and they are experts of the highest caliber, sometimes Nobel Prize winning economists. And it lies in the nature of the policy challenges that financial crises raise, that there isn't a technical answer, and that experts, in this case the economists and others, will disagree and might vehemently disagree on what the correct policy response is. So yes, there can be some assistance that can be given by experts, and the most highly qualified experts imaginable, to investor-state tribunals to assess whether the state has breached its obligations under the applicable investment treaty. But I do think that considerable uncertainty about what the correct policy response is, or there is often not a correct policy response, there's just a series of really bad options, calls for a very broad margin of appreciation. And I do think that, and that takes me to the last part of your question, that we have seen an evolution in that direction in arbitral practice, that is how investor-state arbitral tribunals have approached these disputes, and that trend, I think, will get further impetus from the newest generation of investment treaties.
And Anna, would you share with us?
I try to be brief because I think our time is going to I mean, time is almost over. Technical capability, I agree with David and with both David and Michael. I do not believe that international adjudicators, as far, particularly the one who are going to apply investment law, both general and treaty, really need to have a specific expertise in financial or banking law. I think the same is true for human rights adjudicator, human rights adjudication. I mean, these provisions are required to be applied, I mean, to an open number of sector. I mean, such provision have a cross-sector application. So we cannot really, that doesn't seem to me reasonable to require to adjudicator to have a specific technical competence. I also believe that if I look at the case law, the overall case law, arbitrators has not done a bad job overall. As that this is can be a very tricky, I mean, the problems raised by the presence of experts can be very tricky, in the sense that some tribunals, particularly tribunal deciding disputes in the early case law, has been blamed for having accepted the opinion of one expert without any critical assessment. This was, I think, the a criticism expressed by one of the ad hoc committee in a committee of annulment in respect to, I don't remember, Sempra, I believe. You know, I think that in this respect, I would like to say that tribunals have not to judge whether or not a certain course of action have been correct. This is not the role of international law. I mean, and I think that the last wave of cases have emphasized this point. A tribunal cannot and should not second guess policy choices of respondent states. So the kind of review tribunals have to do is more external. They are not domestic courts, they are not supreme courts of the respondent states. So the kind of review such tribunal have to do has to be external. They have to secure an external control over the action of states, and they have to pay due deference to the policy decisions of respondent states.
Excellent. So before we continue, we have roughly 10 more minutes to go, and we have a couple of questions from the attendees. We can definitely tackle at least one or two of them. A technical note, I already shared on the screen the CLE Continuing Legal Education Credit Code. I want to say it out loud as well. It's 528272. I'm going to repeat this at the end of this panel session. And so let's tackle one of the questions we received from the attendees, and I'm going to invite all of you to respond. It's a broader question, namely how many international arbitration entities are there at present, and which is the best one in terms of cost and effectiveness? What percentage of international investment contracts use the arbitration mechanism to settle disputes? We already heard some statistical data from David, so let's see how you see these questions. David, maybe you could start.
Well, so our focus in the panel has been specifically on generally investor-state dispute resolution, and I mean, I think a lot of our conversations about treaty-based investor-state dispute resolution, and the dominant entity for resolving investor-state disputes has been ICSID at the World Bank, and the major alternative is well, for an ad hoc arbitration organized by the Permanent Court of Arbitration in The Hague, or in some cases, Stockholm Chamber of Commerce. And well, they have different advantages and disadvantages, and a lot of them have to do with the enforceability of the ultimate awards. Now, as far as the percentage of, I defer to my panelists on the percentage of investment contracts that actually include an arbitration clause under that refers to one or more of these institutions.
Michael?
Thanks. Well, I'm not aware of any comprehensive examination of all investor state contracts, so I'm afraid I can't really help on that point either.
Anna?
Yes, me too. I mean, I'm not able to give a precise answer to the question. Apart from from adding one footnote to what David has already said, that the dominant, the leading center in the field is certainly ICSID, followed by the permanent court, or say UNCITRAL arbitration. Then David mentioned before that there were a few cases, ICC cases. I can just add that as far as I know, there was also a case, an arbitration treaty-based case at the Stockholm Chamber. It was a case started by a Polish investor against Cyprus. As far as concern investment agreements and clauses in investment agreements, I would say that the only thing I can add, but maybe Michael is for sure more expert than me in the field. I do not think that as far as we speak about financial instruments, arbitration clauses are very, very common, honestly. I think that the classical choice of forum clause in financial instruments defer disputes to domestic courts of very renowned and important financial centers such as New York or London or Frankfurt. But maybe I remember that when we both were at the Hague Academy, there was, I mean, we attended a seminar held by an institution which was pushing a little bit arbitration clauses, the inclusion of arbitration clauses in financial instruments, but I'm not sure that the attempt has been very successful.
I could just add to that.
Yeah.
I do think my understanding is that the use of arbitration in certain derivative instruments is increasing. Even if not necessarily in typical sovereign bond instruments.
Do you have any regions in mind regarding this, or it's a general observation?
No, I don't think it is specifically a regional phenomena.
Thank you. So we have 3 more minutes. I would like to raise one more question we received. It's a broader question, and I invite all panel members to quickly share your views. It's regarding the enforcement of settlements. Do you see any changes, positive or negative, in that respect? Any views on the enforcement aspects of the issues we've talked about today?
I mean, in my view, I don't know that. Well, so of settlements or of awards, settlements is well, I guess there are new international instruments for that, but for award enforcement and for settlement, there's nothing unique about awards arising out of financial disputes in the banking and or investment disputes in the banking and finance sector. That the enforcement will be under the standard international conventions that that apply to these different types of instruments, the settlements and the awards, so ICSID Convention, New York Convention, and the like. I think for most of these disputes, in the end, depending on who the respondent state is that has lost, or if the investor lost and has a cost award against them, the big issue is oftentimes just finding assets that can be attached.
So much. We have 1 more minute, so I'm going to wrap up this discussion. Thank you so much for the panel members and the attendees for having attended. We have learned today that this is a growing area, as David highlighted. We also heard some limitations from Anna and Michael. Thank you so much for everyone again. And I think we had a very fruitful debate. I've definitely learned a lot. And again, you can see the CLE credit code in the chat box. Again, it's 528272. Thank you very much.
Thank you. Thank you
very much.
Yeah, thank you to panelists and to Virág. Thank you.
Thank you.
I appreciate it.
Goodbye.
Goodbye.
Bye.
Hi, Michael. Bye-bye.
Bye, David. Bye, Virág.
Bye, David. Bye, Virág.
Bye.